Okay, so welcome back, guys. So before the break, we were discussing about the legal reasons for managing health and safety. And under the laws, the employers have certain responsibilities. Now, the term employer means someone who hires other people to work for him. The employer can be a single person, it can be a group of people, it can be the board of directors, it can be an organization. So, employer is a very common or a vast terminology used for some entity or some person who employs other people, and the workers are usually referred to as employees. So if you're working for someone, you are an employee. And if you hire other people to work for you, you are an employer. So the law sets responsibilities. So these are legal responsibilities. कानूनी जिम्मेदारियां हैं ये. These are legal responsibilities which have been set for the employer. Now, as I discussed before the break, at the International Labour Organization (ILO), it what you call it has conventions related to health and safety, and the convention which is important, which you need to remember related to health and safety, is Convention C-155, because it specifies how the employers can manage health and safety, and basically these requirements are taken by various countries and these are embedded into their national laws, into their national legislation. So these are basically legal requirements. So these are the legal responsibilities of the employers. And as per Article 16 of C-155 Convention, it identifies obligations placed on employers to: number one, ensure that the workplace, machinery, equipment, and work processes are safe and without risk to the health. Okay. So basically, in this one sentence, we have defined many responsibilities. The employer is responsible for providing a safe workplace. Okay. He is responsible for providing safe machinery. He is responsible for providing safe equipment. Okay. He is responsible for providing for safe processes. So usually what happens that in a paper, the question might come. So basically, as I told you guys, the question paper for unit 1, it is going to be scenario based paper. Okay. So you will be given a scenario about a company, and the question might be asked about that company, that is that organization fulfilling their legal responsibilities or not. Okay. So that scenario will contain information that the employer has not provided pedestrian crossings. Okay. So if they don't provide a pedestrian crossing, it means that the workplace is not safe and they have not fulfilled their legal obligation. So the question will be from the scenario: read the scenario and confirm whether the employer is fulfilling their legal responsibilities. Okay. So the employer's legal responsibility is to provide a safe workplace. How can the employer provide a safe workplace? By making sure that there are separate routes for pedestrians and vehicles. Who are pedestrians? Pedestrians who are people who walk on foot. So pedestrian and vehicles, if they are not segregated and the workers are walking and vehicles are passing, there is a high risk of accident, which means the workplace is not safe. So if they provide segregation, if they provide a proper route for the vehicles, a separate route for the pedestrians, that means they have taken control measures to protect the workers and the vehicles. So that is a safe workplace now. So if in the scenario they have mentioned that there is no segregation, no segregation, you can say that the employer has failed to fulfill their legal obligation of providing a safe workplace because they did not provide segregation for personal and vehicles. Okay, so this is how you will answer the questions. I will give you detailed questions and answer later on, but this is just to give you an idea of what you need to remember. Okay, also the employer responsible for ensuring safe machinery, equipment, and work processes. All of these have to be without any risk to the health of the workers who are working in the workplace. Also, the employer's responsibility is to ensure that chemical, physical, and biological substances and agents are without risk to the health when protective measures have been taken. Okay. So, what else is the responsibility of the employer? The employer must ensure that all chemicals in the workplace, they should not have any risk to the health of the workers. Okay. So you must make sure that you provide safe chemicals. Physical agents. So the employer's responsibility is to protect the workers against physical agents in the workplace. Okay. What are physical agents? Physical agents are noise. Okay. Physical agents are vibration. Physical agents are radiation. Okay. Heat, temperature. So all of these are physical agents. So if the employer has not taken any steps to protect the workers against noise, it means he is not meeting his legal responsibility. He is in contravention of the law. The employer is not meeting his legal responsibilities and he is not in compliance with the law. He is in contravention of the law, contravene. What do you mean by contravene? Contravene means break the law. If the workers are not protected against noise, the employer is contravening the law. If the workers are not protected against vibration, the employer is contravening the law. If the workers are not protected against radiation, employer is contravening the law. If they're not protected against heat. So all of these things are part of the employer's responsibility. And if he does not fulfill these responsibilities, it means he is in contravention of the law and he can be prosecuted. Okay. So that is very, very important. So as you see from one of these items, we can make 1, 2, 3, 4, 1, 2, 3. So we can make 5, 6 points out of each of these points. Okay. So this you need to keep in mind when you attempt the paper as well. Okay. Then also it is the employer's responsibility to provide adequate protective clothing and equipment to prevent risks of accidents or adverse health effects. So this is the employer's responsibility to protect the workers, to provide them adequate protective clothing. What do we call this? So it is called PPE. What does PPE mean? PP means personal protective equipment. Okay. What is personal protective equipment? Personal protective equipment includes your safety helmet. It includes your safety goggles. It includes your coveralls. Okay, the clothes which you are wearing. So all of this is known as personal protective equipment or PPE. So the employer's responsibility is to provide adequate protective clothing and equipment to prevent the risks of accidents. Okay, also it is the employer's responsibility to provide a safe place of work. He must provide safe plant and equipment. He must provide safe systems of work. What are safe systems of work? Having a PTW or a permit to work. A permit to work basically ensures that before starting any high risk job, you take permission and the work can be done in a safe manner. Having LOTO system, lockout, tagout system, that is also a safe system of work. GSA or job safety analysis is also a safe system of work. Having standard operating procedures, SOP, this is also a safe system of work. So there are many types of safe systems of work which are used in the market globally. So employer responsibility is to provide safe place of work, safe plant and equipment, and safe systems of work as well. Also, he must provide adequate training to the workers. So if the employer has not given any first aider training to his workers, or any firefighting training to his workers. Okay, it means that he is not fulfilling his legal obligation or legal duty. So it is the employer responsibility to provide adequate training and adequate supervision as well to the to provide adequate training and supervision, and also competency of the staff. The employer needs to make sure that the staff that he is providing is competent. Okay, so these are the obligations or legal responsibilities of the employer. Okay, further, now we discuss the responsibilities as explained in C-155. As I told you, ILO issues conventions and recommendations as well. So the convention which focuses on employer responsibility and C-155, this is further translated by R-164, which is a recommendation. Okay, so ILO recommendation R-164, it is expanded under Article 10 and it shows the further detailed responsibilities of the employer. So Article 10 of R-164, it states that the employer is responsible for to provide and maintain workplace machinery and equipment and use safe working methods. Okay, so he must provide, first he must provide a workplace which is safe. He must provide machinery which is safe. He must provide equipment which is safe, and he must also maintain the workplace as well. How can an employer maintain workplace? For example, you need to carry out regular cleaning, you need to carry out regular housekeeping. So if there are objects lying around, there is no housekeeping being done, and oil, etc., is spilled on the floor, it means the employer has failed to provide a safe workplace, to maintain a safe workplace. Okay. So the employer responsibility is to maintain a safe workplace, which he has failed to do so because there is oil spilled on the floor, or there are poor housekeeping is observed in the work site. So that is something which is in breach of the employer's responsibilities. Also, you need to maintain machinery as well. So if the equipment or machinery, if there is no PPM, PPM stands for Planned Preventive Maintenance Program. Okay. So if the employer does not have a planned preventive maintenance program, that can result in a breach of the law. So the employer is breaching the law, is breaking the law. So that is why we need to make sure that he has what you call it adequate maintain workplace machinery and equipment, and also use working methods that are safe as well. So these are the employer's responsibility. Then Article 10 of R-164, it says that employer must give necessary instructions. Sorry. The employer must give necessary instructions, training, and supervision in application of these health and safety measures. So it's not only sufficient to provide safe places of work and safe machinery and everything, or safe equipment. The employer must give adequate instructions, training, and supervision so that the workers can use these health and safety measures. So the employer needs to train the people on the safe use of equipment, in the safe use of the workplace and machinery. And he must provide adequate supervision as well. He should give adequate instructions. How can you give adequate instruction? Simple, by putting a small poster in the front of a vehicle so that they know how to operate the vehicle safely. Okay. How do you provide training? You can provide defensive driving training to the drivers. How do you supervise them? You assign a transport coordinator to supervise or monitor the driver, or you provide a road safety coordinator to supervise them. So these are the legal responsibilities of the employer as per R-164. Then the employer must introduce organizational arrangements relevant to the activities and size of undertaking as well. Okay. So if there are 500 people in a workplace, you cannot get away by providing one first aid box. Okay, you need to provide one first aid box for every 100 workers. You need to provide one first aider for every 50 people. So giving one first aider for 500 people, not sufficient. You need to give at least 20 first aiders for 500 people, because there should be one first aider for every 50 people. That's a legal requirement. And there should be one first aid box for every 100 people as well. Then the employer must provide adequate PPE, personal protective equipment, and clothing without any charge to the workers. So if you're an employer and you're providing PPE to the workers, you do not have the right to charge them any money. You cannot ask them for money, okay, for PPE. Then the employer basically has to ensure that the work organization, particularly the working hours and the rest breaks, they do not adversely affect their occupational safety and health. So if your working hours are from 6 a.m. to 8 p.m., is this okay? No, this is too much. This is excessive working. Usually the employers, they can ask the workers to work 8 hours a day, okay, with 2 hours extra overtime, which has to be paid by the employer or with additional charges. So usually if you are working 8 to 10 hours a day, that is sufficient. But if you're working more than 10 hours a day, that will cause fatigue, it will cause tiredness, and it means the employer is not managing your working hours properly. Also, during these 8 to 10 hours, you have to get regular rest breaks. This is part of your what you call it working hours, the rest break, okay, and it's a legal requirement to provide rest breaks. So they need to provide rest breaks, and it should not adversely affect their occupational safety and health. Then we have the employer must take reasonably practicable measures with a view of eliminating excessive mental and physical fatigue. Okay, so the employer needs to make sure he has practical measures in place so that he can eliminate excessive physical and mental fatigue. Then the employer must keep up to date with scientific and technical knowledge to comply with the above requirements. So if there are any new scientific technologies which are out, or any new technological findings have come into light and new technical knowledge is available, the employer must be able to take use of this, take benefit of this as well. So these are the employer's responsibilities as per R164. Now we talked a lot about the employer responsibility. Employer has to do this, he has to do that. But the workers have certain responsibilities as well. What are the responsibilities of the workers? Let's discuss them. The workers have responsibilities and rights as well. Sorry. It's not only responsibilities, the workers also have certain rights. So workers have responsibilities and they have rights. So Article 19 of C-155 also places obligation on the workers, which is expanded under R164 as follows. So the workers are responsible to take reasonable care of their own safety and that of other people as well. So the workers, they must take care of themselves and they must take care of other people working around them. So if you are a worker and you're carrying out the work, you have to protect yourself and others who are working around you. So you cannot basically do something which can put other people at risk. For example, if you're carrying out welding and there is another worker working nearby and the welding sparks are falling on him, that is wrong. You're not meeting your legal obligation because you are putting your colleague at risk. Okay, so you cannot put others at the risk of injury. So you have to take care of your own safety and the safety of other people who are working around you. Then the the worker, they must comply with the safety instructions and procedures given to them by the employer. Okay, so the employer's responsibility is to give instructions. The worker's responsibility is to follow the instructions. Okay, and follow the procedures. If the workers don't follow the safety instructions, if they don't follow the safety procedures, it means they are wrong. They are in violation of the legal requirements. They are in contravention. Okay, so what is the terminology I used earlier? Contravene. Sorry. Just 1 second, guys. So the workers, if they are not following the legal requirements and the legal requirements are not being met, it means the legal requirements are being contravened. So you are contravening the legal requirements if you're not following the instructions of the employer. Then the worker, they must use all equipment provided, safety equipment provided to them, and they must use it properly. So any personal protective equipment which is given to the workers, they must use it properly. Any safety devices which is given to them, for example, if they're given a vehicle, that vehicle must have a seat belt. So that is safety equipment. It must be used properly. If they're given a safety harness while they're working at height, they must use that properly as well. So they must use all safety equipment provided to them properly. If they don't use it properly, again, they are in non-compliance of the law, or they are in contravention of the law. And what will happen if they don't comply with the law? They can face penalties as well. Also, the workers, they must report any situation that they believe could be a hazard and which they cannot correct themselves. Okay. And also they must report any work related injuries or ill health as well. Okay, now the workers' rights. Workers have certain rights. So Article 19 of C-155 states that the workers must be given adequate information on actions the employer has taken to ensure their health and safety. So they have a right to be informed. The employer must tell them what they are talking about, what they are taking actions to protect them. So it is their right to know the information about actions that the employer is taking to protect them. They must be given the right to the necessary training in safety and health. So the workers must get adequate training. They must be consulted by the employer on all health and safety matters and related to their work. And they must be given the right to leave a workplace that he has reason to think presents an imminent danger and serious danger to his life or health, and must not be compelled to return until it is safe. So if an employee or worker thinks that this situation is dangerous, that this work which I'm about to do is dangerous, he has the right to leave that workplace. If he feels that his life is in danger, if there is an imminent danger, threat to his life or health, he can say no and he can leave the workplace, and the employer cannot force him to go back to work if the worker thinks it is unsafe. Okay, so these are the rights. So the law has given a lot of rights to the workers as well. Now, the role of enforcement agencies is very, very important. Enforcement agencies, they basically are there for implementing the law. They basically do a lot of efforts. Now, globally, there is no international or harmonized standard as to what enforcement agencies should be available, what should be their role. But normally, countries, they may have their own specific agencies, which may include health and safety enforcement agencies. Like in Abu Dhabi, they have OSHA. Similarly, they might have fire authorities. Like in Abu Dhabi, they have the Abu Dhabi Civil Defense, Department of Civil Defense. Insurance companies are there as well. So these are agencies which can have an influence on health and safety. Police may be involved in enforcing the health and safety law as well. Now, what happens to you if you don't follow the law? What are the consequences of non-compliance? So if you contravene the law, or if you don't follow the law, what could be the consequences that you might have to undergo? Number one, you might be held in the breach of the legislation, and breach of the legislation is a criminal offense. So breach of health and safety legislation is usually a criminal offense. This can lead to number one, enforcement actions or prosecution. Okay. So the enforcement actions, it might be an improvement notice or a prohibition notice. Okay. So these are legal breaches. So a legal breach may lead to an improvement notice. An improvement notice is issued when the employer or the company, they are in breach of the law, but there is no serious threat to anybody's life or anything. It's a minor thing. It's a minor non-compliance and they can rectify it immediately. So in that case, the legal inspector is going to issue an improvement notice to the company to improve their situation. Okay. If there is serious threat to the life of someone, they might issue a prohibition notice. So if there is a risk of somebody getting seriously injured, the prohibition notice will be issued, and the prohibition notice, it will prohibit you from working. A prohibition notice means you cannot work anymore, you cannot work any longer, and you must stop and you must rectify the situation. Okay. Then there is prosecution. Prosecution basically, it is when the organization is taken to the court and legal proceedings are prosecuted against them. So this is known as prosecution. When official case is filed against the company, that means they are taken for prosecution. What is the outcome of prosecution? The organization may be fined. They might get serious fines. They might get penalties. The individuals involved, they might be fined, or they might be imprisoned. Or in some cases, they might face both. They might be fined and imprisoned. So there can be serious consequences of non-compliance with the law. So we must make sure that the legal requirements are always met with. Now, then there are other requirements, other international standards, which are not mandatory, but these are good things to have. Okay. So basically, ISO, which is the International Organization for Standardization. ISO is the world's largest developer of management standards. For example, ISO 9001, which is a quality management system standard, ISO 14001, which is environmental management system standard, ISO 12100, which is about safety of machinery. All of these are international standards, but they are not mandatory. These standards are not law, they're good management practice, and they lead to a worldwide common approach to good management of health and safety. Now, the health and safety related law, health and safety related standard is ISO 45001. So the internationally recognized standard for occupational safety and health is currently known as ISO 45001, which is compatible with ISO 9001 and ISO 14001. So these are the international standards, and ISO 45001 is related to health and safety. Here are various sources of information. You can go to the Health and Safety Executive website, hsc.gov.uk, osha.gov, osha.europa, and commerce.wa. Okay, now as we discussed, there are various people involved in the organization. First of all, there is the employer. The employer is a person or organization that employs people, that hires people. The employer in this context is normally an organization such as a company, and it is sometimes referred to as a corporate body. So you can be a board of directors as well, and they are considered as a legal person. The employer has a responsibility for ensuring that the workplace is safe and free from health risks. This lies with the employer, as we discussed in C155 and R164. Employer carries the ultimate responsibilities for ensuring the workplace is safe and free of health and safety risks. And he must ensure that the safety of the workers and others, such as visitors and contractors in the workplace. Now, there are different groups of people involved in an organization. First of all, there could be directors and senior managers. Directors and senior managers, they usually give an organization its direction. Okay. They set all its priorities, allocate resources, and appoint competent persons. allocate responsibilities, and are responsible for ensuring that all the legal requirements are met. Usually, this is known as the top management. Okay, the top management consists of the managing director, and it consists of the other directors reporting to the managing director, and the MD and the directors are known as the top management of the organization. Directors and senior managers can have enormous influence on their organization and its priorities. The way they are perceived by those lower in the hierarchy is very, very important. That is why directors and senior managers must demonstrate clear commitment and leadership with regards to health and safety. Then we have middle managers. Middle managers and supervisors are involved in the day-to-day operational running of an organization. So they are responsible for the health and safety standards within the operations under their control. So we have the managers, the supervisors, all of these people are known as the middle management. They take care of the daily things, all the work which is done, they are responsible for managing that. Then we have shared responsibilities of joint occupiers of the premises. So basically ILO Convention C-155, Article 17, and ILO Recommendation R-164, Recommendation 11. These basically set responsibilities for joint occupiers premises. Employees in shared facilities should communicate to develop appropriate health and safety standards and appropriate policies and procedures. This may include sharing of procedures, for example, fire and emergency response, sharing of risk assessments, and joint management committee meetings. So if more than one people stay in a building, they should coordinate with each other to protect their workers. Finally, we have the last topic for today, which is contractor management. Now, if a client can be held responsible for an injury caused by a contractor working by the client, then it is in the client's own best interest to ensure that the contractors do not endanger their workers or others. So basically, contractors, if they are working for a client, the client can be held accountable for their injuries. So that's why the client must manage the contractors properly. So basically, there are three phases of contractor management. Okay. So the first phase of contractor management is selection of a contractor. This is the most important phase. If you select the wrong contractors, it means you are going to suffer. So you need to select contractors properly. Then we have planning and coordinating the work. So after you've selected the contractor, you need to plan things properly and you need to coordinate the work properly. Then there is monitoring and managing the work. So once you have appointed them, they have started the work, you monitor their work and manage them appropriately. Okay, so when you're selecting the contractor, you need to check a lot of things. So usually when we are selecting a contractor, this is known as the pre-qualification phase. Pre-qualification and selection. Pre-qualification and selection, you need to consider a lot of things. First of all, you need to look at the health and safety policy of the subcontractor. Do they have a good health and safety policy? Do they have adequate risk assessments? Okay, are they capable of producing good quality risk assessments? You should also look at the qualifications and training records of the contractors. Do they have the necessary qualifications and adequate records are available or not? Also, you need to look at the membership of professional organizations. Do they have any membership of professional organization bodies or not? You should also look at the maintenance and equipment testing as well. Previous or current clients should be considered as well. You can talk to their previous clients and their present clients and get feedback as well. Also look at their accident records, any previous accident history is there or not. Enforcement actions should be considered. So you need to look at any enforcement action which needs to be taken, and adequate resources have to be provided as well. So you can look at their resources. Do they have adequate resources or not? So you need to look at all these things when you are selecting a contractor. So look at their policy, check their risk assessment, check their qualification and training records, check any memberships of professional bodies, look at their maintenance and equipment testing records, check feedback from their previous or current clients, check their accident records, their previous enforcement action records, and check if they have adequate resources or not. Then we have planning and coordination of the work. So when you are selected the right contractor, planning and coordination should be fairly easy. So information to be shared between the client and contractor regarding hazards posed by the site and the work carried out. Also the hazards posed by the contractor's activities, risk assessments and method statements are done as well. So basically you carry out risk assessment. That risk assessment must be carried out jointly, so the contractor involved, the method statement should be developed jointly as well. Also, you need to make sure you do adequate planning and coordination. So once the work is about to begin, you need to plan, coordinate things properly. So the arrangements between the client and contractor should include ensuring that there is no conflicting activities. So basically, there might be the client's workers who are working, and the contractor might want to work in the same place. So usually this is managed by implementing a permit to work system, PTW system. Okay, so the contractor will carry out, before they carry out any work, they must obtain a permit to carry out the work. So PTW is implemented to ensure activities don't conflict, and permit to work system to control the activities implemented. Then monitoring and managing the workers, the work of the contractor is very, very important. The client, they must monitor the work to ensure the safety. So the client usually do this by appointing their own supervision, their own staff, they assign their own safety people, they assign their own quality people, they assign their own supervisors. So the contractor's work must be monitored closely. The client must monitor the work to ensure safety. The client can stop the work if it involves unsafe practices, and auditing should be done against the agreed method statement. And that is a good technique to monitor and control your contractors. Okay, guys, so that is the end of our first session. That is the end of element number 1. So now we have completed the first chapter of IG1. Okay.